Chapter 6 Topics. At the bar. Nominated for Attorney General. Correspondence with his Democratic competitor. Defense of Comptroller Flagg. Burdell will contest. Pennsylvania Coal Company. Professional gains, habits, etc. The wreck of the Democratic Party in his state and in the nation, and its incurable division on the slavery question, left Mr. Tilden free to devote himself entirely to his profession, in which, in spite of political distractions, he had secured already a firm position. From this time forth, and until he practically withdrew from it with an ample fortune, he had little to do with politics except as a sort of privy councillor and loyal citizen, in both of which capacities his influence upon public affairs grew with his growth and strengthened with his strength. As early as 1855 he had attained that degree of prominence in his profession which entitled him to be regarded by his party as an available candidate for the important office of Attorney General of the state. It was the year when a wild prejudice against foreigners and Roman Catholics had temporary possession of the country, and most of the candidates of both the old parties in New York, including Mr. Tilden, fell before it. He allowed himself to accept this nomination, which was made without a ballot and by acclamation, a compliment which political conventions rarely pay to their candidates, because it was thought he would strengthen the Free Soil wing of the party with which he was identified, and because, if elected, of which, in the then schismatic condition of the New York democracy, he had little, if any, expectation, his official duties would all lie in the line of his profession. In view of subsequent events, it may be worth remarking here that the only resolution or declaration of principles of this convention was the following, offered by John Van Buren and unanimously adopted. Resolved, that while the democracy of this state will faithfully adhere to all the compromises of the Constitution and maintain all the reserved rights of the states, they deem this an appropriate occasion to declare their fixed hostility to the extension of slavery into free territory. The Democratic Party was still divided against itself, and struggling under the disadvantage of two state organizations. In the progress of the canvass, Mr. J.S. Sutherland, the hard-shell candidate for the office of Attorney General, seeking to score an advantage by trying to place Mr. Tilden in an attitude of hostility to the prevailing political influences at Washington, addressed to him a letter dated October 12, 1855, in which he offered to withdraw as a candidate upon the following terms. I was nominated for the office of Attorney General of this state by that portion of the Democratic Party of the state called the Hards. You were subsequently nominated for the same office by that portion or section of the Democratic Party of the state called the Softs. I look upon the resolutions passed and published by the convention which put me in nomination, a copy of which I herewith enclose, as truly, emphatically, and unequivocally expressing the great principles of the national democracy and of the Constitution. The third resolution, as you will observe, firmly enunciates the great democratic principle that it should be left to the people of the state to determine for themselves all local questions, including the subject of slavery. It expresses also an unqualified adherence to the Kansas-Nebraska bill, and a firm opposition to any effort to re-establish the Missouri prohibition. I approve of these resolutions and have endorsed them, and do now endorse them in letter and spirit. Do you look upon these resolutions as truly and faithfully expressing principles of the national democracy and of the Constitution? Do you approve of and endorse these resolutions? Are you in favor of the Kansas-Nebraska bill, and of the great principle of the exclusive constitutional right and liberty of the people of the territories on the subject of slavery thereby affirmed? Do you believe that, in the organization of future territories, Congress will have no right or power, under the Constitution as it now is, to prohibit or prevent the inception, existence, or continuance of slavery in such territories as a domestic or territorial institution, that the question and subject of slavery as a domestic or territorial institution in the absence of any express provision or clause of the Constitution giving such right and power to Congress, will and must of necessity belong exclusively to the people of such territories of natural if not constitutional right. And the only constitutional and legitimate way which a citizen of Massachusetts or New York can interfere with or act upon that question is by exercising his undoubted right to move to the territory where the question is pending, and to become a citizen or resident thereof. Are you opposed to the organized political verbal black Republican fanatics and demagogues of the North who, using words for things, oppose this great principle and call for a restoration of the Missouri Compromise line? Are you opposed to the state ticket lately put in nomination in this state headed Preston King, and to the declared principles and grounds upon which that ticket was nominated? The opinions, propositions, or principles which would be implied as affirmative answers to the foregoing questions appear to me to be plainly expressed, or necessarily implied in the resolutions of the convention, which put me in nomination, and of which you herewith receive a copy. Please answer these questions by letter at the earliest possible day, for if you answer them in the affirmative, I shall take great pleasure in immediately laying your letter before the State Committee of the party which put me in nomination, and shall at the same time inform that committee that I decline any longer to be considered a candidate. Mr. Tilden, by his reply, so far from giving Mr. Sutherland an advantage, placed him in the very position which Mr. Tilden shows most distinctly that it would be dishonorable for any party candidate to occupy. Dishonorable towards his colleagues on the ticket, and dishonorable towards the body that nominated him. The admirable taste and skill with which he turned the tables upon his competitor is the feature of this correspondence which most entitles it to a place in these pages. Mr. Tilden to Mr. Sutherland. New York, Thursday, October 18, 1855. Dear Sir, I have received your letter offering, on certain conditions, to send your declension to the State Committee of the party by which you were nominated, with my letter of compliance, and to open to me the opportunity of running before that committee for their nomination in the vacancy. I think that, on reflection, you will see that it is impossible for me to entertain any negotiation or discuss any conditions for a fusion of a part of the two state tickets as proposed by you, or of the entire ticket as proposed in other quarters. Still less can I initiate such an arrangement for my individual advantage, irrespective of the other gentlemen nominated on the ticket with me, and which, even if not intended for that purpose, may result in a call on some of them to reciprocate your withdrawal. Discussions as to the feasibility, propriety, or terms of any union of the two tickets belong not to me, but to the party which nominated me, or its authorized representatives. The only countenance I could in any event give to the suggestion would be in retiring myself, and not in being made instrumental or even a party to causing others to do so. Those who have done me the honor to make me their candidate know that no delicacy toward me need restrain them from anything of this nature which they think it advisable to do. Very respectfully, your obedient servant, S. J. Tilden. The case which first revealed to the bar something of the compass of Tilden's professional resources was one more or less complicated by the politics of the period. The ingenuity and novelty of the processes by which he won it deserve to be remembered. In the year 1855, the widespread jealousy of the influence of the foreign population, and especially of that portion of it which belonged to the Roman Catholic Communion in the United States, led, as I have already had occasion to state, to a secret organization of Native Americans who came to be known as the Know-Nothing Party, a name of reproach which they acquired by replying to all questions in regard to what took place in their lodges or secret councils. I don't know. In the fall of that year this party elected the Secretary of State by 12,000 majority, 5 judges of the Supreme Court, and a formidable minority of the legislature. They had nominated at the same election an obscure mechanic by the name of Giles for the office of Comptroller of the city of New York. The Democratic candidate was a Zarisi Flagg, who, soon after the defeat of Sela's right for governor, had come to New York to accept the presidency of the Hudson River Railroad, then in process of construction, and who, at the time of which we are speaking, was the actual incumbent of the office of Comptroller of that city. When the election returns were made, it appeared that Mr. Flagg, who was a popular officer, had a small majority. The Know-Nothings were surprised and disappointed, the more so as some of their leaders had large bills against the city which Mr. Flagg had not thought proper to pay, and they naturally desired a new and less critical comptroller. What they could not compass by fair means they sought to compass by foul. They procured the issue of a writ of quo warranto requiring Mr. Flagg to show cause why Mr. Giles should not have his place. Mr. Tilden, who had been a lifelong personal as well as political friend of Mr. Flagg, volunteered to defend him in association with Charles O'Connor and William Mem of Arts. The case was heard before the late Judge Emmott and a special jury. James T. Brady and Judge Edmonds, in whose office Mr. Tilden had studied his profession, were counsel for Giles. The return made from the first election district, in the 19th Ward, certified that Mr. Flagg had received 316 votes and his opponent 186. It was claimed by Giles' friends that this was a mistake, that a clerical error had been made and an accidental transposition to Flagg of 316 votes which should have been assigned to Giles, and the 186 assigned to Giles which should have been assigned to Flagg. To maintain this theory, the relators produced one of the inspectors of the election, a reputable man, who swore positively to the result corresponding to the altered tally sheets. They obtained some support from another inspector, and introduced evidence to show that the third inspector was intoxicated at the time the return was made up. They also produced one clerk of the poll who supported their case, and the other was not produced by either party. Some witnesses were also called, who stated that they were present at the canvass of the votes in that district, heard the result proclaimed, and made a memorandum of it in little pocket books, which they produced. The claimants seemed to have monopolized all the proof attainable, and to have left little or nothing for the defense. Add to this, the tally of the regular votes had disappeared, at least could not be produced. The original canvass had been made, as usual, upon distinct papers, commonly called tallies. The split tally comprised 3 foolscap sheets, which contained the original canvass of the split votes, and transfers from the tally of the regular vote, and the aggregate result, showing the number of votes that each candidate had received. The papers of split tallies, transfers, and summaries that were produced corresponded with the oral testimony, and confirmed the relator's theory of the alleged error in the return. Such was apparently the desperate attitude of the comptroller's case when Mr. Tilden was called upon to open for the defense. The defense, if any could be made, had to be constructed upon the basis of the testimony offered by the relator. For other testimony there was none. The return showed, as the law required, the entire number of votes given in the district, and the regular varieties of what are called regular votes appeared from the prosecutor's own oral evidence. On this slight basis of actual testimony, Mr. Tilden constructed an impregnable defense. He had devoted a part of the 2 previous nights in analyzing the transfers and summaries from the lost tallies, and in the process discovered the means of reconstructing those tallies. The governing principle was this, that there being 12 officers to vote for, wherever a candidate on a regular ticket had a vote, 11 other candidates must have received the same vote. Seizing this idea, he went through all the combinations, the results of which appeared partially on the split tallies and the transfers, and by means of these combinations, 84 in number, he succeeded in a complete reproduction of the missing tallies. These results contradicted and completely disproved the pretended transposition of votes, and gave a mathematical demonstration that the relator's case was constructed upon a forgery. In his opening, and after reviewing the weak points in the testimony of the relator which he was enabled to discover by the light of his midnight researches, he, for the first time, gives an intimation to his adversaries of the weapon he had improvised for their destruction. If, by a violent blow, he said, I should break out the corner of the stable, split a piece off, the fractured and abraded fibers of the wood would be left in form so peculiar, that though all human ingenuity might be employed to fashion a piece that would fit in the place from which the fragment had been broken, it could not be done. These things that are the work of God are so much superior in texture to anything we can do, that when they are broken up our ingenuity cannot restore them. There is doubtless some difficulty, occasionally, in interpreting this sort of evidence, or rather in ascertaining enough of the associated facts to found your reasoning upon. And when you think you have to meet a fabricated testimony, what you have to do is to study all the other facts, and all their relations to the particular facts in question, so that you can spread out a full map of the fabricated testimony in equal detail. If, after all this has been done patiently and thoroughly, if the lie escape the ordeal, I shall believe that the God of justice and truth has not well constructed the work of his hands. He then placed in the hands of the court and jury printed copies of his reconstructed tallies, and of all the regular tickets, and went over them step by step, with the jury, pencil in hand, by which process they were enabled to perceive and demonstrate each for himself the impossibility of the alleged transposition. Before Mr. Tilden took his seat the case was won, and the leading witnesses of the relator were demonstrated perjurers, and his whole case of bungling, conspiracy to get possession of the auditing machinery of the city. Within 15 minutes after the case was submitted to the jury, and without any interchange of opinion, said one of the jurors, they returned a verdict in favor of Mr. Flagg. To appreciate fully the importance of this decision, it would be necessary to recall the grave issues pending at that election, the vast interests depending upon the retention of Mr. Flagg in office, and upon the defeat of the corrupt conspiracy by which it was intended to oust him. It would be necessary to know what amount of fraudulent bills which Mr. Flagg had refused to audit were depending on the success of Mr. Giles, whose chief witnesses were more or less dependent upon the owners of these claims. It is not, however, necessary to know anything of all this to appreciate the originality, the ingenuity, and the boldness which were required to conceive and execute a system of defense which literally snatched victory from the jaws of despair. Mr. O'Connor, one of the associate counsel, has been heard to speak of Mr. Tilden's opening in this case as one of the most remarkable intellectual efforts he had ever witnessed. If anything could add to the value of such a compliment from such a source, it would be the fact, which it is but justice to Mr. Tilden to record here, that he rendered his services in the case gratuitously. The notoriety which this controversy had acquired, the multitude of the interests depending upon it, the ingenuity by which the counsel for the relator was surprised and disarmed, all conspired to place Mr. Tilden at once in the rank of those who are destined to become leaders in their profession. 2 years later Mr. Tilden achieved another and, in some respects, even a more signal professional triumph. On the 1st of February, 1857, one Dr. Harvey Burdell was murdered in his own house. Mrs. Cunningham, a widow lady, and her daughters, to whom he had rented a portion of his dwelling, were suspected of the murder, tried, and found not guilty. Soon after her acquittal she applied to the surrogate for letters of administration and a widow's third, on the ground of a private marriage solemnized shortly before Burdell's death. Mr. Tilden was retained by the heirs of Dr. Burdell to contest the fact of the alleged marriage. In this, as in the case of Mr. Flagg, his adversaries had all the affirmative testimony, the marriage certificate, the positive oath of the clergyman who solemnized the marriage, the testimony of the daughter Augusta, who was claimed to be the only witness of the alleged ceremony, and the subscribing witness to the marriage certificate, and of the 2 serving girls employed in the house. For the defendants there was no affirmative testimony whatever. Their only resource was the evolution of sufficient evidence on the cross-examination to overthrow the compact and careful array of the testimony of the petitioners. Though satisfied in his own mind that Burdell had been murdered, and by Mrs. Cunningham, and never married, Mr. Tilden found himself unable to produce a single witness who, from personal knowledge, could testify as to any important fact about either the murder or the marriage. He had, besides, to contend with the indefatigable energy of the petitioners in producing willing witnesses ready to supply any defect in her case as fast as it was exposed. Mr. Tilden adopted a course which, though not entirely original in the profession, was probably never more skillfully and effectively put in practice, proceeding upon the principle which guided him in his defense of Mr. Flagg, that the truth in regard to any particular fact was in harmony with every other fact in the world, and that a falsehood could only be even apparently harmonized with a limited number of facts. He determined to conduct his defense by a species of moral triangulation. 150 witnesses were examined in the case. Tilden first allowed the witnesses to tell their stories as they had been taught to tell them, and then questioned them in regard to other facts holding certain inevitable relations to those elicited on the direct examination, but which possessed in themselves no particular importance. The object in fixing these points, in driving these stakes, as it were, being to preclude the possibility of bringing new witnesses to explain and alter the original statements without involving a contradiction with these collateral facts. In this way he was enabled to take up the main witnesses, who were few in number, and gradually force them, by rigorous cross-examination, from one point to another, until they would contradict some of these preliminary assertions. That accomplished, they were soon demoralized and broken down. The success with which this process was applied, especially to the Rev. Dr. Marvin, who thought he had performed the ceremony of marriage, and of the daughter Augusta, who swore to the room and bed of the bride and groom's cohabitation, was fearfully complete. Though they had at first sworn positively to every essential point in the case, before they left the stand they were not only completely discredited, but they did not leave a single presumption in favor of the marriage. He showed that the clergyman had innocently, perhaps, married another man, and not Burdell, and that on the night of the alleged marriage, instead of sleeping in the room adjoining the doctor's office, as Augusta had sworn, the widow in point of fact slept on the floor above. That Dr. Burdell was in Herkimer County on the Sunday preceding the marriage instead of being in New York, and was in Brooklyn visiting a cousin till after 8 o'clock of the evening of the alleged marriage at 7, as sworn to by the Cunningham witnesses. It is scarcely necessary to say that the surrogate did not confer letters of administration upon Mrs. Cunningham, or leave her any further pretext for wearing the widow's crape. There is probably no case in which Mr. Tilden has been employed that required the exercise of so high a range of metaphysical powers, or in which his penetration of character appeared to greater advantage. His defense seemed almost a creation, and the result produced the more profound impression, as it removed whatever doubt existed in the minds of the people as to Mrs. Cunningham's participation in the murder of Burdell. The conviction took immediate possession of the public mind, that had Tilden conducted the case for the prosecution when she was under indictment, she would undoubtedly have been convicted. This case occupies 147 pages in the 4th volume of Bradford's reports. Though Mr. Tilden exhibited in both of these cases, as in all the great cases with which his name has since been associated, extraordinary ability, he did not win either merely as a lawyer, and it is worthy of remark here that though, like Webster, Mr. Tilden is rarely spoken of or regarded by the public as a lawyer, his professional endowments, like Webster's, representing such a limited proportion of his power, he won these suits by the happy combination and exercise of qualities which are not the exclusive or peculiar property of any particular profession. He was not only a lawyer, he was a political economist, he was a logician, he was a politician, he was a man of the world. In a trial, therefore, he had many resources which are far from common, even among the most eminent of the profession. It was this superiority and breadth of development which early in his professional career made his office the favorite resort of large numbers of the great railway corporations of the country, which for some years immediately preceding the war were beset with the troubles consequent upon a management more or less incompetent, corrupt, or indiscreet. His success in all these great cases was due not more to a knowledge and appreciation of the principles of law than to his familiarity with those broader principles of the science of government, legislation, and finance of which he was a master. In no case that specially engaged his attention did he fail to show originality in its treatment and a fertility of resource which rendered him measurably independent of precedents and authorities. This independence was conspicuous in a suit in which the Pennsylvania Coal Company were his clients. The Delaware and Hudson Canal Company had a contract with the Pennsylvania Coal Company by which, among other things, it was agreed, in case of the enlargement of their canal, the coal company should pay for the use of their canal extra toll equal to such portion of 1/2 the reduction in the expense of transportation as might result from such enlargement. In due time the canal company put in their claim for extra toll. The coal company denied that the cost of transportation had been reduced, or that they had derived any advantage whatever from the enlargement. After tedious and futile negotiations, suit was instituted by the canal company, and Mr. Tilden was retained for the defense. The case was tried before Judge Hogemam, of the Supreme Court, sitting as referee. 70-odd days were consumed in the hearing, and the testimony offered by the plaintiff fills several large printed volumes. As in the Flagg case, the plan of the defense advised by Mr. Tilden was a surprise both to court and counsel. By a sort of necromancy, which he seemed to have always at command when needed, he smote all their testimony as with a blight, and rendered it utterly worthless. The question was, whether, in point of fact, the enlarged canal had furnished more economical transportation than the smaller canal had done, but there were an infinitude of facts which seemed to complicate the question and render it nearly incapable of an entirely satisfactory solution. The difference in size of the boats used, the difference in loads, the different periods of detention in loading and unloading, the difference in the length of seasons, these and many other questions rose to embarrass the problem and to multiply witnesses. In meeting this difficulty, Mr. Tilden's originality, courage, and conscientiousness all appeared to great advantage. What he did we may as we're spelled W-E-I-R, quote in his own words in summing up the case. At quite a late stage, comparatively, in this case, when I intervened and undertook to ascertain the relative time of the trip, I did as I always would, if possible. In such a case I endeavored to simplify the controversy by applying a test which made all this part and many other parts of the discussion unnecessary. I took a simple integer with which to compare the time of the trip upon the old canal and the time of a trip upon the enlarged canal. The number of trips a boat would make during a season of navigation was subject to be varied by causes affecting the length of the seasons, by the question whether navigation was for 179 or 185, or any other number of days. It was also subject to be affected by the question whether the boat was all the season in use upon the canal, or was part of the season running upon the river. It was subject to other elements of disturbance and irregularity. I discarded it and took a single trip as the integer, and made my computations, as later in the day I shall endeavor to show your honor, upon the time of the trip considered singly, causing to be examined and computed every trip made by the plaintiff's boats in a period of 4 years upon the old canal, in a period of 4 years upon the enlarged canal, every trip of which the books of the plaintiffs give a complete record, and from them deduced an average time, which I computed as the time of a single trip and made my integer. I was, therefore, enabled to dismiss altogether from my investigation the question whether this particular canal boat number 1 was upon the canal the whole season, or 6 months, or 3 months, or 1 month, or for how long a period it was upon the river. I got as my result what that boat did while and whenever it was actually upon the canal. It may have been unfortunate that this mode of treating the question did not receive earlier and more general attention, for the habit formed of talking about the small number of trips made by the boats on the enlarged canal as resulting from the employment of the boat for certain days, or certain parts of the season, upon the river and not upon the canal, has survived all necessity for the discussion of any such facts. A liar less courageous or less conscientious than Mr. Tilden would have hardly ventured upon such an expedient, for besides involving a fabulous expense of both money and time, if the plaintiff's claim was well-founded, it would have as effectually demonstrated that fact as it actually did demonstrate the reverse. Some notion of the amount of labor required for the preparation of these tables and of the argument that was based upon them may be gathered from the following paragraphs of Mr. Tilden's closing argument. I advised our clients to tabulate and ascertain the time of the trips of all the boats during the entire period between the notification of the completion of the enlargement and the commencement of the suit, taking the navigation seasons in which these events happened as complete seasons, and having a fraction before and after these two dates, and to make a similar tabulation in respect to the boats on the small canal for an equal period. It certainly took all the influence I had and pretty nearly exhausted it to get this done, because it was a pretty large job. You have, sir, in these tables equal to, at least, 12 years of the labor of a single man. You can read and perceive results here in 5 minutes, which, if the whole 32 volumes of the plaintiff's books were brought into court, and your honor should spend the next 12 years in examining them, you would scarcely discover. That was a laborious and costly process. Perhaps it might appear, now, to be unnecessary. It was intended to be decisive. It is, I think, decisive. I remember an anecdote which ex-President Van Buren once told me of John Randolph. Somebody was speaking to him in a complimentary vein in reference to a debate in the House of Representatives, and told him that a speech of his had not been answered. Answered, "Thrice," said he. "It was not made to be answered." And so, these tables were not made to be confuted. They are made according to the best process of scientific analysis, proved, step by step, from the records of the plaintiffs themselves, and are introduced here in strict conformity to the rules of evidence. They will establish and do establish the proposition they were intended to determine when I did not know, and nobody knew, what the result of the investigation would be. Never, sir, anywhere, or on any other occasion, was there such a body of evidence upon any such question involved in litigation. By these tables, and by taking a single trip as the integer, Mr. Tilden rid the case of the question of the duration of particular seasons and all the testimony that related to it, and in getting rid of that he got rid of a second, whether the boat was used part of the season on the river and part of the season on the canal, for it was evidently immaterial how many trips the boat made in a season. The point was what time it took to make one trip. If he could deduce the law governing the navigation, if he could show that the navigation on this enlarged canal during the period in question was governed by a constant, uniform law belonging not only to fast trips and to slow trips, but to all the trips, there was an end of all the talk and all the testimony about the specialties and peculiarities of a particular season during the 4 years in controversy. The tables proved to a mathematical demonstration that the round trip on the enlarged canal took 40% more time than the small boats in the original canal, and that by diminishing the aggregate of the service during a given time, the cost of transportation was proportionately enhanced. There was no possibility of escaping or resisting this conclusion, and a verdict was given accordingly in favor of Mr. Tilden's clients. The amount claimed was 20 cents a ton on an annual transportation of 5 or 600,000 tons a year for some 10 years, besides a royalty of the same amount for an indefinite future. It was a crisis in the fortunes of the Pennsylvania Coal Company. through which it was successfully conducted by a device which only a great man would have had the ability to invent, only a brave man would have the courage to suggest, and to which only a thoroughly conscientious man would be willing to trust. Among many other cases in which Mr. Tilden was engaged, we will allow ourselves to refer to one in which his strictly professional abilities appeared to special advantage. In the year 1858, the Cumberland Coal and Iron Company brought suit in the New York Supreme Court against two of its directors, and the president of a company of which the said two directors owned practically all the stock, to set aside the sale of a large tract of the plaintiff's lands, which by fraud and misrepresentation the said directors had induced the plaintiffs to alienate to them, and for an injunction against the transfer of said lands to the company of which the said directors held all but 10 of the 5,000 shares. Upon a motion to dissolve this injunction, Mr. Tilden and C. Rappel appeared for the coal company. The feature of Mr. Tilden's argument was his successful effort to extend to corporations the important doctrine that trustees may not become purchasers of property confided to them, nor traffic at all in the property of their sesquittanists. Note: the sesquitrust is the person entitled to an equitable, as opposed to a legal, estate in the trust assets. Thus, if land is granted to A for the use of B while in trust, with remainder to C when the trust terminates, as the trustee, B is sesquius and C the sesquitrust. Trusts are created only upon the conveyance of property. Upon these points this is now the leading case. Mr. Tilden's success in rescuing corporations from unprofitable and embarrassing litigation, in reorganizing their administration, in re-establishing their credit, and in rendering their resources available, soon gave him an amount of business which was limited only by his physical ability to conduct it. Since the year 1855, it is safe to say that more than half of the great railway corporations north of the Ohio and between the Hudson and Missouri rivers were at some time his clients. The general misfortunes which overtook many of these roads between 1855 and 1860 called for comprehensive plans of relief. It was here that his legal attainments, his marvelous skill as a financier, his capacity for concentrated labor, his constantly increasing weight of character and personal influence, found full activity, and resulted in the reorganization of the larger portion of that great network of railways upon conditions by which the rights of all parties were equitably protected, wasting litigation avoided, and a condition of great depression and despondency in railway property succeeded by an unexampled prosperity. Mr. Tilden's professional career was singularly marked by his individuality. Whether in court, in his office, or on the highway, he exhibited none of the badges of the conventional lawyer. His law training seemed in him like the mastery of a foreign tongue, as subordinate to more important uses. His acquaintance generally no more thought of him as a lawyer than we are wont to think of Milton as an organist or of Gladstone as a woodchopper. Skill at the bar was simply one of his accomplishments. He always lived a larger life than was expressed in his profession, and for larger purposes than winning the suits of his clients. And yet no member of the legal profession in New York ever accumulated so large a fortune or won for himself a more enviable professional reputation in so short a time. Neither did he ever have, in the common acceptation of the term, a very large practice. His power lay in the thoroughness of his preparation. He was never content to go into a fight of any kind without forecasting and providing for every contingency that could be anticipated, and he spared no amount of time or labor in the effort to place his clients in positions to defy the caprices of fortune. He concentrated his energies entirely upon cases involving large, often enormous interests, cases requiring the exercise not only of great abilities, but more time and personal attention than lawyers with a large office practice can usually afford to bestow. The litigation of cases of minor importance he neither invited nor encouraged, and if such business came to his office it was confided to his subordinates. His professional charges were exceedingly moderate, and were graded upon the amount of work done, rather than upon the advantages realized from such work by his client. This with him was a matter of principle, and he distrusted the clients who came to his office with gross retainers. In one of his communications to the public he said, "I declined retainers from Fisk in matters involving no scandal, but in which he had not my sympathy after he had informed me that he had paid counsel, during the year, many times the largest fee I had ever received," adding, "We don't want anybody else, we want you." In repelling an assault made upon him some years later by a corrupt judge in New York City whom Tilden had been instrumental in impeaching, he made some statements which set forth in impressive terms the ethical principles which controlled his professional life. He was charged with receiving a retaining fee of $10,000 from the Erie Railroad for which he did no work, and for which he was expected to do nothing, unless it was to compromise himself in the interest of the rogues who then had possession of that corporation. The late George W. Cass effectually disposed of the imputation in his reply to a letter addressed to him by Mr. Tilden, near the close of which Mr. Tilden said, "I do not mean to say that it might not happen that a retainer is sometimes received and yet no further services rendered in the case. I presume that this often happens without impropriety. I have only to say that, so far as I recollect, it never has happened to me in any single instance of my professional life. I have been content to receive compensation fixed by agreement with my clients after the services were rendered. I have in no instance had any controversy or difference of opinion with any client as to the amount of compensation. I have never heard of any discontent after the settlement, unless this may be such a case. Since there is an elaborate attempt to misrepresent an act of my professional life, I have a right to say this, without the imputation of egotism, and I have a right to add that, for the last 16 years, at least, my only trouble has been not to accept more business than I could perform according to my standard of duty and justice to those who entrust their affairs to my management, that I have not accepted half which has been offered, of cases in which the clients were willing themselves to fix my compensation to my full satisfaction out of what they would recognize as acknowledged benefits. And I have never hesitated to choose what business I would decline. At the outset of the famous litigation of the Erie, under the presidency of Mr. Eldridge, it was communicated to me that the Erie desired to retain me, and afterward Mr. J.C. Bancroft Davis, in its behalf, twice came to my office to offer me retainers. I declined. In 1869 Mr. James McHenry, when acting in apparent unison with the Erie, several times pressed upon me retainers, in behalf of his scheme of reorganization of the A&G.W., but after considering his scheme, I declined. In the same year Mr. James Fisk, Jr., called upon me with Mr. J. Good. Mr. Fisk said, with many flattering suggestions, that they desired to retain me in reference to a matter then pending, and in the course of the interview he stated that they had paid within a year $125,000 to a member of the bar whose name he mentioned. I declined. I do not mean to imply that there would have been anything wrong in acting as counsel for Erie in a proper case, but simply, when an act of mine is challenged, to state facts which are pertinent to my vindication. I have ever stood, not only in my personal conduct, but in my public influence, for the dignity and honor of the bar and the purity of the bench, and against whatever should tend to weaken or degrade the administration of justice. I did so in 1869, when the evils of corrupt times were growing and powerful. I accepted issue in the Democratic State Convention of that year. On the 1st of February, 1870, at the meeting which resulted in the formation of the Bar Association, I uttered these unpremeditated thoughts. If the bar is to become merely a method of making money, making it in the most convenient way possible, but making it at all hazards, then the bar is degraded. If the bar is to be merely an institution that seeks to win causes, and to win them by backdoor access to the judiciary, then it is not only degraded, but it is corrupt. So, I believe that this country is tonight at about the lowest point in the great cycle which we have occasionally to traverse. I believe that there will come a sounder and a better public sentiment, in which speculation, and gambling, and jobbing, and corruption will lose their power, and in which free government will vindicate its right to the confidence of mankind. If I did not believe this, I should think that a very great part of my own life was lost, and all the traditions I have derived from my ancestors. It is not to be wondered at, says James C. Carter in a recent admirable sketch of Mr. Tilden, that with his profound knowledge of the causes by which human affairs were controlled, combined with such capacities for skillful action, he should have accumulated a large fortune. Aside from what he received for professional services, his large gains were, I imagine, rather easily acquired. Among the mischiefs of an unstable currency is the facility with which men who have the power of dealing skillfully with exceptional conditions may amass large fortunes. Few men understood such things better than Mr. Tilden. He had striven to prevent, as well as a man in opposition could, the issue during the war of an irredeemable government currency, but I remember his saying to me after the policy was adopted, in substance, "Now is the time to make yourself rich. Buy all that you can pay for or run in debt for. Every day it will be easier for you to pay, and your property will correspondingly rise in value, or rather in price." And at the close of the war he advised the opposite course. I do not know, but I have no doubt he acted extensively on this policy. If there were a question about the propriety of such action, he certainly was excusable. Had his counsels been regarded, no such measure would have been adopted. Tilden never allowed himself to accept a contingent retainer. He judged very properly that such a partnership had a tendency to distrust the proper relations of a lawyer with his clients, and exposed him both to temptations and suspicions which were apt to prove inconvenient and sometimes degrading. His propensity to thoroughness in all his mental operations made him sometimes tedious before popular assemblies, but in time it came to be pretty generally understood that he never took the platform without having something to say which no one else was likely to say, and without which the presentation of the subject would have been incomplete. He never lost his presence of mind in court, on the platform, or indeed in any assembly, nor did he ever seem surprised or embarrassed. He has been heard to say that he had great temptation, because considerable faculty, for sarcasm, but that he made up his mind early in life that one may make as incurable wounds with the tongue as with a dagger, and that a triumph achieved by means of a mortifying or humiliating sarcasm is dearly bought at the cost of incurring an enmity for life. He frequently deplored in John Van Buren his inability to suppress a smart thing, whoever it hit and however it might prejudice the cause he might be advocating. Tilden never lost a friend nor made an enemy by this sort of indiscretion. If he chaffed, as he occasionally did, a presuming opponent, he did it in a way that instead of making his victim angry made him grateful rather for his forbearance, and indisposed him to ever again attempt any liberties with an adversary at once so formidable and so considerate. He won his cases, so far as success depended upon himself, by no stage tricks or artifices, still less by any technical subterfuges, but by sheer intellectual force concentrated upon the point of least resistance, which point he was pretty sure to discover before engaging with his adversary. His business habits were about as bad as they could be. One could never count upon finding him at his office. He was not punctual. He would stop and talk for hours with a person casually encountered on the street when he knew clients were waiting for him at his office by appointment. He seemed to have appropriated to himself the prerogative in regard to time which the common law only confers upon kings, and to be under the impression that in the long run the world could lose nothing by waiting for him. This was due primarily to his health, which had prevented his submitting to the rules or enduring the discipline of any well-conducted business. Incident to and consequent upon this neglected training was an utter want of method. Those who knew him well would not be in the least surprised to be told that when in full practice he never endorsed or filed away any law paper or made an entry in his register. But if a paper in any proceeding was wanted, and when called for was not promptly produced, he made the office so uncomfortable for his clerks that they took good care to supply the order and method which he lacked, and for which he was unwilling to expend any thought or trouble. Had not Mr. Tilden's life, like Pope's, been a long disease, and had his intellectual forces been sustained by an unimpaired physique, his success at the bar would probably have been of such an exceptional character that, if it did not gradually extinguish his taste for politics, it would have made him a controlling force in our government at a much earlier period of his life, and, in all human probability, the hero of many and more important chapters of his country's history than it is now my privilege to record. Google, Atlantic Monthly Magazine, October, 1892 article titled, Tilden, written by James C. Carter. End of chapter 6.